Peace FM 104.3. Who to meet Taki?
Yeah, the Pedro Kpandai, justice. The Pedro Kpandai, Kpandai. Kpandai. Justice, any rule of law. Many Penny Collins, before the cameras, now he didn't come. I may catch how. A penasem, there were so many mutual friends. What can I say? Into who say common a buyer, no, or they question about Fedia. Seminar will be son one call and not call baby for the decay. Assembly they call court in January after I say, in fact, ye gusuna ye declaration, you create young gazette, you know, and a Nasara, Eddie Assembly call court. Now, on the authority of Baba Jamano. Court I can say ya to abani wie na say ye declare ni gazette ya o the back court wa prepare wo because okwohwe people representation act ni mu a e kire prefe e kwan ye fa so court e na ye wo time so a say ye gazette wie obetumi so aba court nti asem na e wo court de dada enye say bia na nsen ya na ye de akọ court a o ma bebu ya na wo koye no o kire mu ne win live na ope every court no based on emra Minya Penimua passing or parliament CI 127 say yemfa enhwe yemfa to abano emrano e wasi ediso inti regulation 43 no kire kwan ye fa so eye coalition nasala at that time no no sitting member of parliament ya to abani wiye aye gusu aye kenkan ye gusu aye coalition afedie prekope ye hu ba bia yi si adwane afa Yankoti ayesi isi na kwashe kukuo mbabi ene MPP parliamentary candidate nene omu agents ye coalition ye wie ya wa declare results see I say we dey see pie because we know etia regulation 43 of CI 127 inti apart from that so pin sheets ne bi wo ho do kind judgment about 155 pages the man even judge no kro kasa about a kwanya EC for fast to recruit nkofo a moye EC officials free senior high school until he expects like a basic arithmetic probably or one nkofo be a comprehensive judgment or my na in somewhere yadi kai at stitch union MPP for a creative impression they say before the judge there was nothing like say on annually all the results no more call for Rerun. It was part of the releaser now a petitioner no because in election it is not plaintiff respondent, it is a petitioner respondent. Inti petitioner no at the to court then say and now say your bull regulation 39 so now we share pin sheet no a move 41 there irregularities in kwa na regulation 43 so e was say class na ye to me hwani nyina mu ye ansa na ye declaration so ye ndi so inti court ye serew aba no ebe ya ma yensan so nko na yenkoto ne foforo na sem na okan ye no en judge no tie na sem no na ohwe ase no kura na wo kire Ghana mra the Far Evidence Act ho why na the burden of proof e da ne so eye wo a wo de wasem abeda court no na we eye civil matter ni preponderance of probability wo twa ni nyina na owe ye no otumi hu se petitioner no asem no emu edu inti saade a yenko na yenko ye Rerun enye NDC sebe ena aka se yenko ye Rerun ewo Kpandai eye emra no ena si yenko ye Rerun se emra ne si yenko ye de bembio na emra ne ka emra no so say se ye ma judgment 7 days after judgment no there is stay untumi nye bibia na mom after 7 days no ena obetumi exert wo right judgment ne di amount no nti say 7 days na twam within 7 days no anka clerk etro letter no within 7 days na ko you wrong because emra no etia but after 7 days ne dey say clerk no etro letter koma isia on from Ghana mra bia sisia ye di nkomo and midyanom MPP fo ni nyina akasa menti so bia akasa wa fom mra na emumo say wa prepare no because omo another application for stay of execution and omo asanso file appeal notice of appeal na omo asanso file certiorari e was Supreme Court say court enquashe the decision of the Tamale High Court. Reasons are that omo say court no was not clothed with the jurisdiction to hear the matter. Court so with jurisdiction the man to me. Now I must say, asem no time why the bar court no na emra na chere PNDC law 284 chere say ye to aba wi a utumi di petition ba no atwam eno no Supreme Court ANC ho giraye but ena ye di nkomo nyina no de emra eno de ye di kan ya kan eda ho ne say court ne say yankoye Rerun ewo Kpandai inti omo a state institutions are constitutional omo mandate e was omo ensure say there is an enforcement of that judgment no bako parliament and bako electoral commission. Parliament is active within the law because they waited for the 7 days no emrane ma ho kwan no na Supreme Court swaka ye Ghana ye mra sisi ase application for stay of execution any stay of execution until it is granted inti emrano ewo omani mu de eno na both EC and Parliament adisono se ekoba se court no so esi ginaye foforo na court ne ka say answer monster judgment no mema ye enforce so na court of appeal at the judgment ba na e in the favor of the MPP and answer the appellant and also you do a beji hu komo na ho no na me wo problem kakra me amadan for pa na nabi oye lawyer ni na oye press conference the way o kan asem no ase wo she court of appeal ni say omo mpeo asem ne de e wo se omu bia emomo e ho no me ji say esipai wo de wasem akodan court e na wa kire nyina so a sa nyina so no enu nti anke ni say the lower court which is in this case no the high court esi sa gina ye na osi ye no e wo se jai ama judge for no e de omo adwen based on the law e de omo judgment ba na mom say you criticize the decision of a judge there it is allowed say judgment bia ba na won ti ase obetimi a kire wadwen impo eno no so no mo leader e koyo of us so criticize judgment including the judge no na me doing say enna no yara na mo wa ba mu a o Supreme Court a ompiempo no the judgment aba ena de de be na asesenti a otumi etwabo judiciary ni sa ntiwe bibia nsesan na yese owudi ni bia esuraya ya na ena no na minia Collins mo wa ba mu no ebia na omo influence the judiciary nti omo adwe ni say abai we so bi but I can give them that assurance so man pay mahama any sadrin pono one ekwa ye fa so Chief Justice dada no ebio Ghana ye wo mra ne say obi esusu say obi a ya paw no say wanye Chief Justice wo man mu no adwuma bi a oye no esipai na opesi eyi na e wo say wo tro petition na odisa petition ne ko down omampanyin saka e was say anka import on article 146 no na e clear how you remove it na anka one form committee near establish prima facie but you hu ni say ye ni sa na a disadvantage for Chief Justice in the case of Frank Ajetum and Attorney General and that by JSC as he was then ni say Debbie sa kwan ye fa so other justices of the Superior Court of Judicature no ye fa sa kwan ni bia so na ye ni kan establish prima facie kransa na ye refer Chief Justice no to a committee. Okay. That is the position of the law. Miss a few questions. All right. That is the position of the law. And also maintain that so be can wo baby say samrano o man pay mahama ebu so.
Peace FM 104.3 Good to meet you.